Hi, good afternoon, everybody. Welcome to Ramping Up to the 2016 Cycle, Making Compliance a Priority for Lobbying and Political Activity. I'm Ron Jacobs. I'm here today with my colleague, Larry Norton, and we want to thank you very much for joining us for this webinar. Just to remind everyone that today we are recording the webinar, so it'll be available online for playback, so everyone should know that. All lines have been muted for the call, but we encourage you to ask questions using the chat feature on your computer. You can see the little chat screen on the left side there. So just ask us questions, type them in, and we will answer as we go along. Just a second, we're having a little trouble with the slides here. We are going to cover a number of different topics today. We'll talk about how you can maximize and grow your PAC, hosting different candidate events, we'll talk about Super PACs, state corporate contributions, and using your federal PAC in the states. We'll talk about some of the state pay-to-play rules, and then we'll also talk about some of the changes in the state laws that have been made in the past year. As a reminder, we have a blog, politicallawbriefing.com, so we would, if you're interested in these issues and want to stay up to date on them, we blog fairly often about some of the changes that go on. So with that, we will get started by talking about political action committees and some of the rules that govern those. Larry?
Well, thank you, Ryan. When you talk about political action committees, it's almost required that you start with what you can't make political contributions with, which is your corporation or your incorporated nonprofit or trade association. And so federal PACs, corporate PACs, have existed since the mid-'70s as a carve-out of the corporate ban and a vehicle for allowing a corporation or a trade association or other incorporated entity for raising voluntary contributions from individuals and for making contributions out of the PAC, but using the PAC using the corporation to fund the administrative and the fundraising expenses. So the ban applies to any monetary or in-kind contribution made by a corporate entity to a federal candidate. And notwithstanding all the changes in the law since Citizens United and more recently in the Supreme Court case in McCutcheon, it's still the case that corporations can't make either monetary or in-kind corporate contributions to candidates or to the national political parties like the DNC and the RNC, and can't even make contributions to federal PACs, including their own corporate PACs. What corporations are prohibited from doing directly, they may also not do indirectly. So no end runs are permitted where individual employees may make contributions, but a corporate executive or even the corporation itself reimburses the employee through a raise or bonus. And corporate resources may not be used to facilitate fundraising, and if they are used, there needs to be compensation for them from either a campaign or an individual who's permitted to make contributions. And so that means that if a company is using its customer lists an individual is taking the customer lists and making phone calls to vendors and clients and customers, a customer list has value, and the company needs to receive some reimbursement for the use of it. The same goes for conference space, overnight delivery, and so on. There is a safe harbor for individual employees who are spending company time, working hours on personal individual volunteer fundraising. The safe harbor is no more than 1 hour a week or 4 hours a month. It's important, too, that because corporations are not supposed to be in the business of facilitating contributions or fundraising, that employees who are actively involved in attending fundraising and raising money don't address that activity in employee evaluations and don't receive compensation or advancement based on that. Okay, what is a PAC? A PAC is a separate legal entity. It exists independently of the company as a nonprofit, so that its receipts are exempt as income, although contributions to the PAC are not deductible to the donor. It more or less is a bank account that has to be segregated from all the corporate funds. But as we talked earlier, the PAC may have a relationship with a corporate entity where the corporation provides the PAC with support for fundraising and for operations, for legal compliance and so on. But again, can't actually deposit money in the PAC. And when the corporation has that relationship with the PAC must bear the corporate name must bear the full name of the corporation and the full name of the PAC. And finally, PACs may be used to host fundraising events. The key with a PAC, and Ron will talk more about strategies for fundraising, is that the PAC really exists to further the objectives of the organization or the corporation, not to advance someone's personal political preferences. It's a nonpartisan entity that exists for corporate purposes, not personal ones. This is just a quick look at the contribution limits on funds that an individual may contribute to a PAC and the contributions that may be made by a PAC that has existed for 6 months and met certain other thresholds under federal election law for making contributions. Important thing to remember here is that contributions to a PAC, whether it's a corporate or a trade association PAC, don't affect personal contribution limits on contributions that that individual might want to make to candidates and parties and to PACs that the PAC is also contributing to. PACs may accept contributions from any U.S. citizen or green card holder, but not from foreign nationals or from foreign entities. And PACs may only solicit the restricted class, and Ron is going to talk a bit about that term of art, restricted class, and what that means.
So the restricted class will depend a little bit on the type of organization you have for the connected organization. For a corporation, a business entity, there are a number of categories of people in the restricted class. It includes salaried employees with decision-making authority, so policy-making or managerial type responsibilities. Anyone in the recognized professions, so if your company has engineers, lawyers, those kind of individuals within their employees. Stockholders of the company are within the restricted class, and the board of directors is within the restricted class in most cases for a for-profit, as long as the board of directors either owns stock, or if they're independent directors, if they receive a stipend for serving on the board, which would be the case for the vast majority of for-profit directors. It also includes the family members of all of these individuals. So the company can send letters to all of these people asking for contributions from them and their families, or some of them. For example, it's somewhat unusual to send out a letter to all shareholders, but maybe it's useful for employees who are shareholders of the company that might be solicited. So even if an hourly employee who's now in the restricted class, if that employee owns stock in the company, for example, you could use that as a basis to solicit from them. The restricted class for an association or other kind of nonprofit is a little bit different. It includes executives of the association, so the same group of people with the association that are described on the slide before in terms of corporations. It includes any individual members. So if your organization allows individuals to be the members, they join directly, they may be solicited directly. The next category is a little more complicated. The next two go together. It also allows you to solicit stockholders and executives of your corporate members, but only if you first get prior written approval from the member company. The member companies are only allowed to give one association a year prior written approval. This is probably one of the biggest hang-ups that we see in our practice with trade associations that have corporate members, is figuring out how best to get that prior approval. And usually what it comes down to is explaining what prior approval means to the members in simple language, providing them with options so they don't feel like they're signing a blanket prior approval which gives away all their rights, but that instead maybe limits the number of people that will be solicited, allows the member company to work with the association to do those solicitations. So basically, the PAC, again, it sort of takes in contributions from $5,000 a year from U.S. citizens. One key piece is that you can use payroll deduction, whether you're an association PAC or a corporate PAC. Most of our clients find that sort of by getting people to sign up to contribute through payroll deduction. It's much easier. They don't have to re-solicit them every year. People stay on the payroll deduction until they opt out, and so it's a way to allow people to contribute a larger amount over time instead of having to write one big check at the beginning of the year at the solicitation time. And also that it's an opportunity to allow the people to stay on over time so you don't have to re-solicit them, simplifies sort of the ongoing efforts. This is a chart that shows the contribution limits from the PAC and gives you an example to kind of compare to what an individual can do. The PAC, a multi-candidate PAC, is allowed to give $5,000 per election to candidates, $15,000 a year to party committees, $5,000 a year to state and local parties, and $5,000 to other political committees, which compares to individuals. It's a higher limit to candidates than individuals, but a lower limit to the party committees. We also list on there non-multi-candidate PACs. Those are PACs that have not been in existence for 6 months, who don't have 50 contributors to the PAC, who haven't made contributions to 5 different candidates. There's also a new bucket of how to contribute from PACs and individuals this year that was created as part of the spending bill at the very end of last year. Individuals and PACs now have 3 extra accounts to give to the national parties. So you're all consider yourselves very lucky that you can make these extra contributions to the building funds of each of the national parties, the legal and recount funds, and then for the national parties themselves, there's also a convention fund. So those are additional ways to spend your PAC money. PACs are really one of the most transparent ways to be involved in the political process. Federal PACs are registered with the Federal Election Commission. You have to disclose the name, address, occupation, and employer of all individuals who contribute more than $200 in a year to the PAC. And all the contributions disclosures are done online so people can look that up and see, so it's very clear who's given and who hasn't. Larry touched before on the idea that the connected organization is allowed to provide support for the PAC, to pay all administrative costs, to pay various fundraising costs, but the corporation is not allowed to contribute to the PAC. The key here is that things like bank fees, things like legal fees, administrative fees, all those kind of things get to be paid for by the company. The PAC is allowed to pay for them, but it doesn't have to. So if you make a payment from the PAC would report that as a disbursement. And if the company reimburses that, then that also gets reported on the PAC form. But if the company just pays the cost directly, then it never even has to show up on the SEC reports. And there are time limits on when a company can reimburse the PAC. It's 30 days that you're allowed to reimburse. So it's often advisable to make the contribution initially from the or make any corporate support payments directly from the company. One of the hallmarks of the PAC is that it is voluntary. All contributions to the PAC must be made voluntarily with the person's consent, and it's very simple, and it cannot be reimbursed. So the key is there's no coercion that's allowed to be involved in making the contributions. You can't threaten a person's job. You can't offer to reimburse them. You can't tell them they'll get a bad performance evaluation. So some tips for when you're doing solicitations to help minimize the risks are, typically we suggest not doing one-on-one solicitations with direct reports. So if the boss walks into the employee's office and says, hey, I really hope to get into the PAC, it can create a coercive atmosphere even if it's not intended to. Small group meetings work better. That way there's also witnesses there to sort of make sure there's nothing untoward going on. We suggest you make sure you're not using threatening or harassing language. Don't promise any benefits. And if you're doing follow-up, you follow up occasionally to make sure you're getting the message through that you're asking for contributions. But don't do it too often. Don't do it in a way that people feel it can kind of cross the line into impermissible coercion. So now we've kind of laid the groundwork for what a PAC is, how it works. We thought we'd try and share a few tips we've learned from working with different clients on how to have a successful PAC solicitation and make it more useful.
I think the overarching message in this section is that the PAC solicitation ought not be approached as just another, as a handout for employees to have another piece of their check taken by the company or by insurers or by someone else. That what you're doing when you make a PAC contribution is participating in the future of the company and in your own future, and that you are joining something, receiving something, and becoming part of something larger, and not simply writing a check or having something come out of your paycheck every 2 weeks.
Yeah, we've definitely heard that inviting people to join the PAC is much better than just give us your money. In tying the PAC to business goals, I think is a very important thing as well, so that you help understand, why we have the PAC. It's because we want to support candidates who understand our company, who understand our industry, to support our positions, that by working with these candidates, building relationships, we can create a more favorable regulatory climate, and that through that regulatory climate, we have a much better operating environment for our company. It allows us to grow our business, to grow our profits, meaning it's better for all of the employees.
And as is indicated on this slide, there are all kinds of creative ways that PACs can serve as a platform for interactions with members of Congress, other senior government officials, who are often willing to meet with small groups of employees who participate or are interested, answer questions, talk about matters of public policy. It really can afford the employee an opportunity to speak directly to office holders and decision makers and feel more connected and involved.
Exactly. We've heard a lot of, particularly if senior leadership, CEOs, presidents of the company, chairman of the board, are popular with employees, it's a great way to sort of give them the opportunity to show that they're part of the team and working with the company. We've also found that providing recommended giving levels or creating tiers is very effective. It helps employees kind of get a sense of maybe what others are doing in their area, so that if you go around and you say to an employee, and we hope to contribute to the PAC, they can kind of look around and see what other vice presidents at their level may be giving based on sort of the recommended levels. You create sort of that feeling of inclusion. You create things like chairman circles. And one of the things that we found is effective too is that you can consider suggesting percentages for employees, so maybe 1% of their income for the PAC up to the $5,000 limit. That way, even an employee who doesn't make a lot of money can join at that level and be in that top tier where maybe they get an extra opportunity to meet with the CEO, whereas compared to someone who makes more would give a larger amount.
This is just the small print that needs to appear on all your written solicitations. And solicitation is another term of art, but that the FEC has construed broadly to mean any sort of communication that encourages someone to contribute to a PAC. It's something beyond sort of straight information about how a PAC works or what the contribution limits are and so on. So we recommend that this disclaimer appear at the bottom of emails or letters or any brochures that are provided to employees, and that in fact any oral communication that you make to encourage participation in the PAC, whether that's a small meeting of a certain division of the company or a breakfast that the company is permitted to pay for to roll out and explain the PAC, that everyone receives something in writing that contains this disclaimer that emphasizes some of the things we've been talking about, the voluntariness of the contribution, the fact that it's publicly reported, and that the contributions, unlike charitable contributions, are not tax deductible. One of the vehicles available to corporations in assisting the PAC with its fundraising and operations is that it may provide certain incentives to employees, inducements to contribute to the PAC. And one of the more popular ones listed here are charitable matching programs, which typically the company will provide a list of charities or even give the employee a choice of giving to his or her own favorite 501c3 charity, or asking that their PAC contribution be matched by the company, say 50% or dollar for dollar, up to the amount of the PAC contribution. And that's considered a permissible fundraising cost for the company. It is not, however, a deductible charitable contribution to the employee, nor is it a tax-deductible contribution for the corporation, but it is a very successful way of encouraging employees to contribute. Employees who do contribute through charitable match can't receive any other financial or tangible benefit from either the corporation or from the charity. There's the FEC uses a so-called one-third rule to prevent the corporation from providing such generous, this is more in the case of the prizes and trinkets and so on, that they can't be so valuable that the corporation is effectively recycling corporate money through its individual employees and then back into the PAC. So what the FEC has said as a matter of shorthand is that if you're going to provide a prize to, you're going to have a drawing, a raffle for PAC contributors, that whatever you offer by way of prizes or trinkets can't constitute more than one-third of the amount of contributions that are raised through the fundraising effort. And there's some examples there of the first being a permissible way and then the second being an impermissible way of doing it.
One of the key things, too, when you're figuring out the one-third rule is to figure out what the right numerator is to divide by. So if you're doing a raffle or a competition, if you do it so that everyone who contributes to the PAC in the next month is eligible to win a prize, then you're dividing the contributions by, the contributions that you're dividing are the contributions received within that month. Whereas if you do a raffle at the end of the year, to say everyone who contributes to the PAC in 2015 is eligible to win one of these prizes, then it's your total receipts for that entire year, so you get a much higher number, you get more valuable prizes. It also, if you're giving prizes, that you're looking at just sort of the total revenue divided by the value of the prizes, as compared to if you're giving something to every donor, it makes a big difference. So that if you're giving each donor a coffee mug or some other item, that has to be evaluated against that individual's contribution to the PAC. So if every donor gets a $50 coffee mug, to the extent there's a $50 coffee mug in the world, you would have to make sure that each person gave more than $150 before they could be eligible for that mug.
And that is our complete math course for today.
We promise no more.
Well, timing is everything, and it's no less true when talking about trying to raise money for your PAC. Our experience working with our clients is that after raises are announced and people find them in their checks, or after bonuses are received, is, as you can imagine, an effective time to send around that PAC solicitation or have a meeting to talk to people about PAC contributions. And on the other hand, a really terrible time, or less favorable time anyway, to try to raise money is after April 15th. One thing, though, to be very careful about is if you're going to try to raise money after bonuses are distributed, that you be very careful not to suggest, either not to say explicitly or even to imply that the bonuses were provided in any part to help employees make those contributions. Again, corporations can't make contributions, and they can't do any sort of end run around that prohibition by providing bonuses or increasing the salary for employees.
Now that we've talked about the PACs, we'll talk a little bit about other ways to do fundraising activities. And by other fundraising activities, we mean events specifically for candidates, where you bring a candidate in and help raise money for that candidate. And there's sort of two broad ways to think about doing this. The first is to do it sort of officially with the company's resources. In order to do that, it has to be conducted only with the restricted class. So if it's a for-profit company, it's got that chart we showed earlier with sort of the list of individuals who are salaried employees with decision-making authority. If it's a trade association, it's the individuals with whom you normally conduct your association's business or your individual members. On the other hand, the other option is to do it through volunteer activities. So you can, then anyone's allowed to be solicited, but no corporate resources can be used. So the first option means that you're not using PAC money to pay for it. The second means that you're not allowed to use any of your corporate money. So either a PAC has to pay for it, or the candidate has to pay for any of the expenses. And as Larry talked about before, you have to be very careful not to use corporate resources like lists of vendors or franchisees or anything like that. One of the things we usually say is that if it's your personal Rolodex, that's one thing to sort of use as a volunteer to call into contact. And there may be some of the people who might be on those lists in your personal Rolodex, but it's not a company list that's prepared or generated. You don't go to your marketing department and say, please give me a list of all the companies we sell to or something like that. You want to be very careful about that. many people don't realize that within the company or within the membership of an association, you're allowed to communicate freely with the restricted class. You're allowed to actually ask them for contributions. So it's very important to remember that you can send out invitations to your executives. You can ask them to make the contributions, and then you can hold the event in your office. The key here is that really the one key above all is that the company may not collect the contributions. The exemption for asking for money is really a First Amendment-based exemption so that you can communicate with your restricted class and ask them. Congressman Smith is going to be here next week. We hope you'll be able to join us in the cafeteria for an event with him, to meet with him. The suggested contribution level is $500 or whatever the amount may be. The company may not collect those checks. Either you have the individuals contribute online with the candidate's website or mail the check to the candidate's fundraiser, or they can bring the checks with them to the event as long as there's a representative from the campaign that's there collecting the checks. It's the sort of the no-touch rule. Don't collect checks, don't FedEx checks, don't mail checks using corporate resources, because that crosses that line into the impermissible facilitation that Larry talked about before. On the other hand, if you're going to use sort of the volunteer fundraising exemption, you want to make sure that you do keep it very separate from the corporate realm. So be careful about soliciting your downstream employees, your vendors. You may do so, but you've got to make sure you're doing it sort of not in your official capacity. We often suggest using your personal email address. If you're going to actually mail out invitations, you use your own postage and your own envelopes. We've seen CEOs of very large companies have a separate stack of envelopes, separate stack of stamps ready to go for when they make their own personal solicitations, so that they're not using those corporate resources. As Larry mentioned before, there's the safe harbor to limit your time in the office, 1 hour a week, 4 hours a month. Of course, if you're a salaried employee and you don't work sort of a 9-to-5 job, you can sort of tack on at different times and do different work at different times. But you just want to be very careful about the total amount you're doing, that you're not using up your actual work time, or you're not taking away from your day job in order to be engaged in political fundraising.
We're just going to say a couple of words about Super PACs, which have been very much in the news lately, as not only all the presidential candidates seem to have one, but what we're seeing increasingly is that candidates downstream, Senate candidates, House candidates, even state gubernatorial and legislative candidates seem to have one of these things. And it's helpful to understand what they are, because they really are sort of a separate species of PAC that didn't exist before the Citizens United case and some subsequent court decisions and Federal Election Commission decisions. The concept of a super PAC is that it makes independent expenditures, which means it doesn't contribute directly to candidates, but it funds advertising, get out the vote activities, other kinds of things that are not are expenditures that are not made in consultation with campaigns or their parties or their representatives. Again, doesn't make any contributions to candidates. We talked about coordination a little bit, and this is really a big exception to the general ban on corporate contributions. The Super PAC may accept unlimited contributions from corporations and from incorporated entities. And again, the premise of this, the Supreme Court case suggests that a PAC that is organized in this way and doesn't coordinate its spending with campaigns is at no risk of there's no risk of corruption or the appearance of corruption. And so under the reasoning of the Supreme Court, they can accept these corporate contributions. It's important to remember that the Supreme Court hasn't yet addressed the contribution ban that exists on federal government contractors for making contributions to federal PACs, and the Federal Election Commission has taken the position that notwithstanding the Citizens United decision and subsequent rulings, the ban on government contractors still applies even for contributions to super PACs. And finally, individuals can make unlimited contributions to a super PAC. We have a quick slide here that indicates really how, in fact, PACs, corporations, and associations can all make contributions. There are certain requirements, though, in terms of disclosures paid for by statements that have to appear on public communications, And one of the great misunderstandings about Super PACs is that it's not secret or dark money. All the funding the Super PAC receives and the spending it engages in is publicly reported on filings to the Federal Election Commission, and that would be true for state Super PACs too.
So we thought we'd kind of switch gears now. We've been really focused a lot on the federal. Now we want to spend a little bit of time talking about state issues. And the first thing we'll talk about is making contributions in the states. And unlike the federal government that has the ban on direct corporate contributions, a number of states allow for corporate contributions to be made directly to candidates. So this chart here is designed to help unpack that a little bit. So the states that are red follow the federal model. They don't allow corporate contributions. The states that are green not only allow corporate contributions, but they allow unlimited corporate contributions. You could write a check for $1 billion to a candidate, and it would be perfectly permissible in those green states. The middle tier, the yellow states, those allow corporate contributions, but they're subject to limits. Usually those are either follow the individual limit, or some states have their own separate limit for corporations that are either typically lower than the individual limit. Some states, like New York, have a restriction on the total amount that can be given from a corporation to candidates. Other states impose certain disclosure requirements if you contribute out of your corporate funds. So it's important to understand that sort of the details of the rules behind the permissibility before you start making the contributions.
If you're lobbying in that state, for instance, that may be one way that your contribution, while permitted in a state, may have to be publicly reported.
Exactly. And then there's also an issue with corporate contributions in the states. If you have subsidiaries or related entities, partnerships, there are different attribution rules, so that in some states, a parent and a subsidiary share the contribution limit. Other states allow for each of those entities to have their own separate contribution limit, so you want to be very careful there. The other way to contribute in a state, or another way to contribute in the state, is to use your federal PAC in the state. And the good thing with this chart is that it's gotten greener over time, I would say. It used to be that there were a number of states that imposed some roadblocks to using the federal PAC in their states, but they seem to sort of recognize that federal PACs are very transparent. They're subject to limits. They don't allow corporate contributions. And so what we have here is that states that are in green, and obviously there's a little bit of interpretation here that you could shade some of the green ones yellow, some of the yellow ones red perhaps, but ultimately the green states are very simple to make contributions out of a federal PAC in without having to register or file periodic reports. Occasionally in some of the green states you may have to let them know, send a copy of your FEC registration to the state, something like that, but it's pretty simple. The yellow states do impose some periodic reporting requirements. Either it's registration and then reporting, or you may have to in some of those states you can't use the FEC report. You have to sort of transpose the numbers on their own reporting forms and use it there. And then the small category of red states either just outright prohibit federal PACs from contributing in their states, or they require the federal PAC to comply with the state laws in such a way that it's virtually impossible for the federal PAC to do. So, for example, in New Hampshire, you have to have an in-state treasurer there in order for the PAC to be able to contribute to a candidate. So it could be done, but it would be very difficult. Michigan, we've shaded red because it requires sort of separate registration in the state, but also Michigan has a funny rule that for payroll deductions, you have to re-up every year affirmatively. So instead of, if your federal PAC makes contributions in Michigan, you would have to ask employees to give every year to payroll deduction, as opposed to sort of it automatically going on unless someone cancels. So we've shaded that one red because again, it's just an extra hurdle that you have to jump through.
Well, our next topic are pay-to-play laws, and if your business model in any way involves government contracts from state or local government agencies, colleges and universities, then these laws are very important to you and need to be a part of your compliance strategy. We'll talk in a moment about what pay-to-play laws are, who they impact, where they're in effect, and finally some general thoughts on compliance strategy for dealing with them. But big picture, what pay-to-play laws do are generally a couple of things. One, they either ban political contributions entirely or impose lower limits that would apply to other individuals or entities who can make contributions based on the fact that you either have a pending bid for a government contract or are presently doing business with a state or local government entity. Some pay-to-play laws require that if you're a bidder, if you have a proposal or bid pending, or you have government contracts, that you file periodic disclosure reports with the government indicating certain political contributions that have been made by the entity and by affiliated entities and individuals. And then in a number of states, there are both bans or limits and some kind of disclosure where there are limits, there are also disclosure obligations. And some of the states that ban political contributions also ban fundraising. The important piece here, and it's a tough, it's sort of a tough concept for many of our clients to get their minds around, is that pay-to-play laws ban the political contributions not just of the bidding or contracting entity, but personal contributions made by certain affiliated individuals like officers and others. So again, even if those contributions have absolutely nothing to do with the company and are made out of personal funds and are written by somebody on their own time, the pay-to-play laws may restrict or outright ban those personal political contributions. Pay-to-play laws come in all sorts of flavors, and we've highlighted in the next few slides some of the major considerations. One important distinction that separates pay-to-play laws is which contracts they cover. There are certain pay-to-play laws that apply, that impose restrictions or disclosure obligations only on sole source contracts or contracts that are awarded outside of the competitive bidding process. Other states apply their pay-to-play laws to all contracts. There may be a dollar threshold applied, or only certain types of contracts may be subject to the contribution restrictions or the reporting obligations. Again, I spoke earlier about how the restrictions on government contractors and bidders at the state level apply not just to the contribution by the contracting entity and usually its subsidiaries and parents, but also to personal contributions made by owners, usually over a certain threshold like 5%, 7.5%, to officers and directors, and generally to employees who are involved directly in the government contracting process, either negotiating contracts with the government or supervising the contracting process. And there are, as we note there, a couple of states where the contribution restrictions apply not only to the corporate officers and directors, but to their spouses and to their children who live in the same residence.
This is really a tough area for people to sort of accept, because usually the corporate policy says, what the company does is the company's business through its PAC. What individuals do is up to them as long as they don't use company resources. But here what you're saying is it's not just up to you for what you're going to do. It really relates directly to your personal political activity that may have nothing to do with the company's business, may be limited. In some cases, the company will be able to say you can't make those political contributions because it will cause us to lose the ability to seek a government contract.
Yeah, it really does collapse the distinction between the personal and the business. Again, pay-to-play laws will also vary in terms of which contributions are restricted or prohibited and which require disclosure. So approaches will vary as to whether the pay-to-play law applies to all public officials or candidates in the jurisdiction or some subset of officials. Some pay-to-play laws apply to political parties and PACs, and some don't. And again, back to our red, yellow, and green chart, this gives you an overview of state pay-to-play laws. That is, laws that are enacted as a matter of state law, although in some cases apply not only to state elections, but also to local elections. That's another area that varies. There are, I think, 20-odd states that have restrictions on giving or some combination of restrictions and reporting, and a handful of other states that just require reporting. But that's the map as it exists today. There are a couple of jurisdictions. Rhode Island, Maryland is looking at strengthening its pay-to-play law. It's an area that's been very fluid over the last several years as the media in particular has focused on the relationship between the award of government contracts and some political contributions that were made by key company officials.
One of the things too about these slides, particularly the red states, some of these don't apply to all kinds of contracts. There may be somewhere it's a particular kind of contract in the gaming industry, for example, or Florida's are focused on some of the financial arrangements if you're looking to manage pension fund money in Florida. So just because it's red doesn't necessarily mean that every contract is subject to it, but that they have a state pay-to-play law. We wanted to be as inclusive as possible as we created this chart.
It's impossible to provide you with an exhaustive list of municipalities, city and county governments that have pay-to-play laws, but here are some of the prominent ones. And note New Jersey, which is really the mother of all pay-to-play law states, that has very draconian state and local pay-to-play laws and is quite serious about enforcing them, they frequently invalidate or disqualify bids and void contracts based on sometimes relatively small individual contributions.
So it's really important to remember sort of what's at stake here and how best to try and manage these issues. As Larry said, New Jersey is known as the sort of the quintessential pay-to-play state. Now, I would also say that New Jersey is a state that's known as a pay-to-play state, and that's the reason why they have so many of these restrictions. I often say you look to whatever states have the most recent contracting scandal, and you'll find a new pay-to-play law there. New Jersey being one of the prime examples. And as we mentioned before, it's not just the corporate, it's the personal as well. And so one of New Jersey's enforcement actions was against a road contractor when the president of the company, at the request of a friend, had given a contribution to a state political party, thinking it was a way to help the party that he was interested in, help his friend raise some money. And the net result was the company was banned for a period of 3 years from seeking contracts, and in fact had a contract disqualified. They had won the bid. They were the low bidder on the contract to do this road work, and because of this contribution from the president of the company, they were disqualified from the contract. So it's really important to remember that you can't take these lightly. It's not just the potential for fines, but really losing a good chunk of the company's business. And so there's a few things you can do, I think, to sort of assess the risk and figure out how best to deal with this. The first step is to figure out who are your covered employees. Go through and figure out, okay, it's these top 5 executives or it's this group of people who manage the contracts with the state, and then figure out what states you're doing business in, matched up against the red chart, the red states and the green states. Where does the company plan to do business? One of the tough things, if you're not a New Jersey contractor, New Jersey has a very long look-back period of several years. So if, let's say you're an Ohio company complying with Ohio's pay-to-play law, and you happen to have an employee who gave a contribution to the governor of New Jersey, and that's a covered employee, you're going to be timed out from receiving the contract. So it's very important to make sure that you've got, that you're thinking prospectively of where you're going to want to do business, where you have offices, and what the enforcement climate is in those different locations. So once you figure out who those employees are, you probably want to provide notice to all those covered personnel so that they know what the key requirements are, adopt policies and procedures. It may be that you've got a pre-clear contribution. That it's not just, they can't just make contributions and tell you about it, but you really have to pre-clear them. You want to make sure that you have a backstop in place, so maybe you're going to review your records online. Most places states require disclosure of donors, so you can go through and look at your employees periodically and figure it out. You want to make sure you're doing training and that you're keeping the record. Some states require fairly extensive record keeping and reporting. Even Maryland, where there's not a prohibition, the reporting requirements are fairly onerous to make sure that you're disclosing what needs to be disclosed. So you really need to make sure you've got a good, solid compliance plan in place before you have government contracts, before you move into new states with government contracts.
So as we move toward the close of our presentation, we want to highlight some of the major changes in state law either campaign finance, lobbying, disclosure, or government ethics in 2014 and in the early part of 2015. I'm going to move through these quickly so we can leave some time for questions that you might have before the end. But the states, really, unlike the federal level, have been the laboratory for change and the driver for change. And it's rare that any year goes by where there aren't lots of changes in state laws. And as Ron said earlier, usually driven by some scandal or something that got a lot of media attention during the year. One trend that is interesting to note over the last year is that a number of states have been increasing their contribution limits. In many cases, their limits on individual contributions and increasing corporate contribution limits. And this is really a way that states are sort of reacting to the unlimited contributions that corporations, that Super PACs are able to accept, and the disadvantage that places on candidates and political parties that remain subject to so-called hard money limits. And so sometimes these laws are enacted with a trade-off where there's more disclosure by Super PACs and other nonprofit entities in exchange for allowing candidates and parties to raise more money. And here are half a dozen states that all, just in the last year, have raised their limits on contributions to candidates, to parties, and to PACs. Got a number of other slides just to highlight some important changes over the last year. Arkansas, through a ballot measure, it actually moved into the red column in terms of a state that's banned, where individuals, where corporations rather, and unions are banned from making contributions to candidates and others. And there's now a lobbyist gift ban that is on individual lobbyists and their employers, with very few exceptions. The Arkansas gift ban is often referred to as a no cup of coffee rule because there's so few exceptions as exist under other state laws for making gifts if you're a lobbyist or a lobbyist employer. California has a very strange rule that bars lobbyists from conducting fundraising in their own home, and we have a blog, our politicallawbriefing.com blog, where we talked about this in some more detail.
It even goes into apply to spouses or adult children who live in the home aren't allowed to have fundraisers in their very own home if they live with a lobbyist.
Delaware also made lots of changes in its pay-to-play law, so corporations and other business entities that are permitted to make contributions in Delaware, but they're required to provide the recipient committee with the name and address of the quote-unquote responsible individual, which could be a director or an officer. And they're also required to identify any individual who holds a 50% or greater interest in the business entity, and that individual is considered to have made a contribution in the same amount as the business entity. District of Columbia has closed what is commonly referred to as the LLC loophole. This is where it typically arises in connection with real estate companies that have a different LLC established for every project, and were able to make separate contributions that each complied with the contribution limit, but collectively blew way past the contribution limit. And so now in DC, those contributions are considered aggregated for purposes of the contribution limits. There are also disclosure requirements now where campaigns are required to disclose contributions that individuals have raised through so-called bundled contributions. Illinois governor, Illinois is one of those states that, as Ron said earlier, there's a scandal, there's a pay-to-play law, each governor wants to trump the last one. In this case, there's an executive order that eliminated almost all the gift rule exemptions that existed for gifts to state employees. Maryland has very comprehensive reform in the campaign finance area for 2015, vastly expanded their pay-to-play reporting by government contractors, including real estate companies and others, are required not only to disclose every 6 months the political contributions that are made by covered individuals, but also to file on their report with the Board of Elections very specific information about the government contracts they have, and even to disclose the existence of a new contract within 24 hours of its award. Maryland also, like DC, closed the LLC loophole and has new independent expenditure reporting. Massachusetts has an interesting requirement that within 30 days of the appointment of a political committee treasurer, campaign committee, or PAC, that treasurer must take online training program that is provided by the state in order for the committee to be in compliance, which is, I think, a relatively unusual requirement in the campaign finance space.
Yeah, and you'll remember that Massachusetts is one of those red states on the PAC chart, so if you're going to give if you're going to give contributions in Massachusetts, you have to have a separate Massachusetts PAC, therefore your treasurer will have to receive that online training.
Also been big changes in Oklahoma over the past year. That they've changed the gift rules considerably to tighten them up, eliminate exceptions, and they've banned gifts from government contractors, from bidders and those who have proposals pending, and from their sales agents. And that's sort of an important component of the pay-to-play restrictions we talked about earlier, that we focused on campaign contributions, but it's very common that states also impose gift bans on government contractors or lower limits on government contractors, as well as lobbyists and lobbyist employers. In Virginia, of course, Governor McDonnell was convicted, along with his wife, of violations that concerned gift rules, and predictably there was a reaction in the Virginia state legislature to limit gifts from lobbyists and lobbyist principals, and also from bidders and government contractors. Virginia, like a lot of other states, gift bans provides lots of exceptions for and running the gift rule restrictions.
Virginia was one of the interesting states. They have unlimited campaign contributions, but they also, until this new law, had unlimited gift rules. So it's interesting that the governor was convicted of accepting gifts, but it was not a violation of gift rules for him to accept those gifts. There was a disclosure issue that Virginia had, and that it was the corrupt intent that was the issue there, but there weren't particular limits like there are in most states about, you can only give a $10 lunch, or a $5 cup of coffee or something like that.
And finally, just to wrap up, we wanted to talk a little bit about just generally how we suggest approaching risk management, and some sort of general philosophies and principles in terms of best practices. Starting out with having simple and clear policies and procedures about all these things, about individual political fundraising, about lobbying and gifts to government officials, and typically these are contained in a code of ethics or code of conduct, but there's something that needs to be communicated to all employees, and particularly new employees, so they understand what the rules are, who they need to contact if they have questions.
You want to make sure you're providing regular training on those policies and procedures, whether it be as part of the onboarding process for new employees or periodic annual training. It doesn't have to be over elaborate, but it should be provided on a regular basis so people know what's going on. As rules change frequently in the states, they need to be familiar with those.
Again, as a matter of best practice, it is desirable to have the responsibility for compliance exist outside of the government affairs office or government relations office. And it's common that the compliance office or the legal department feels like they've just got enough on their plate and they don't want to have to worry about lobbying laws and campaign finance laws. But it really is just that general idea that it's good to separate, it's good to have some separation between the people who are actually engaged in the activities and the people who are responsible for making sure they're compliant.
And just keep in mind that this is a heavy regulated area. There are many traps for the unwary. You want to make sure that you've got everything in place. You want to make sure that you ask first, whether it be an employee asking or whether it be the company asking its counsel, to make sure that they know what the issues are, who's involved. There's usually a way in this space to accomplish your goals. You just have to know what it is and how to do it. Maybe it's a slightly different approach than what you had in mind. The fundraiser that you were going to hold on the company property, maybe it has to be held off-site at a restaurant that somebody else pays for. But overall, it's there's usually a way to make it happen. But you've got to do it ahead of time, not before or not after the fact. It's much harder to fix things than it is to structure them correctly in the first place.
We often say to people, as many of you say to your own children, that it's good to take a step back and think about how it would look if it were publicly reported. It's important to remember that all these activities we're talking about, the campaign finance, the lobbying and the gifts. Much of this is publicly reported. There are lots of eyes on what you're doing by your competitors, by watchdog groups, by the press, and you can get very wrapped up in what the rules are and the technical exceptions and easily lose sight of the bigger picture, which is this a good idea? How would this play if it were publicly known, and how might this affect our reputation? And so it's always good to have somebody who can encourage everybody to take a step back and look at it from that perspective.
So that's the end of our presentation today. We have a couple minutes left. If you have any questions that you'd like, use your chat box function to enter them in, and we'll try and answer them as best we can.
Cynthia, we had one question earlier about bank fees and whether it was permissible. I guess the questioner says that the PAC's bank fees are automatically deducted from the PAC bank account, and the question is it permissible for the corporation to reimburse the PAC bank account for the bank fees? And the answer to that question is yes. It is permissible. There's a certain period of time, and I think it's 30 days, where the reimbursement has to take place, and the reimbursement would be reported on the PAC's FEC report. So you report that the money came out of the PAC account, and you'd report that the corporate contribution, the corporate reimbursement was made to the PAC for the fee. And there's a particular way the FEC likes that reported that's laid out in the campaign guides for corporations, but it's perfectly permissible to do it that way.
One thing to think about as well is that if you have your PAC bank account at the same bank where your corporate accounts are, sometimes the bank will let you directly deduct the PAC banking fee from your corporate account, and then you don't have to go through that whole set of hoops of doing the reimbursement. So you're trying to work with your banker may assist with that problem.
So we had a question about associations and pay-to-play rules and whether there are particular concerns that trade associations ought to have about pay-to-play laws.
Yeah, I think in my mind, there's sort of two issues there. One is that generally the association is not going to have contracts itself, so it should be okay that the association doesn't have to worry about it. But the key is whether, if your members are subject to pay-to-play laws, whether your association PAC could cause a problem. In particular, one thing we didn't talk much about are the federal pay-to-play rules. The SEC has a rule that comes into play so that if in there it's covered associates is the key term that are managing money for states. So if they contribute to an association's PAC, can the association then contribute to a candidate that's covered by the rules? And generally, the rules often don't reach exactly that, but usually there's a prohibition on sort of doing indirectly what you can't do directly. And many associations that have members who are in those heavily regulated industries that are subject to federal pay-to-play rules will adopt policies that they don't contribute to state candidates, or they don't contribute to certain kinds of state candidates to avoid that problem.
So I think we've come to the end of our hour. I want to thank everybody for joining us today. Appreciate your making time and hope this was valuable to you. We also, again, want to remind you that we do blog on all of these issues because they are fast changing, and we want to make sure that people are aware of the changes and also what they mean in a real practical way. We encourage you to check out our blog at Political Law Briefing, and if you have any questions, please don't hesitate to give us a call.
Great. Thank you very much, and a reminder that the full presentation will be recorded and on our website with the slides as well.
Thank you.